Hi, my name is Paul Taylor-Sussex from Nelligan O'Brien Payne, and today we're chatting with David Contant, one of our commercial litigation lawyers. Welcome, David.
Thanks, Paul.
Today we're talking about Bill 142, which proposes some pretty major updates to Ontario's Construction Lien Act. David, maybe to start with, you can talk about the Act itself and why it's being updated.
Sure. So the Construction Lien Act is a legislative scheme that provides protection for contractors, subcontractors, and other players within the construction industry. And it has two main remedies, the construction lien remedy, and there are trust remedies. And the reason the Act is being updated is that the Act really hasn't been changed since 1983. And if you think about it, that was the era of Pong and Pac-Man, and the world's changed a lot since that time. And while the Act still has a lot of practical remedies, it needs to be updated and modernized.
Okay. So we're going to talk about four of the most significant changes proposed by the bill. Maybe you could first talk about the prompt payment system. So what's the process with that one?
So the idea behind the prompt payment system is to establish some certainty in terms of when contractors and subcontractors can be paid. So the general idea behind the prompt payment provisions is that once a contractor delivers what's described as a proper invoice to the owner will then have 28 days within which to pay that contractor. And in turn, upon receipt of payment, that contractor will have 7 days to pay their subcontractor. Now, there are mechanisms within that scheme to deliver a notice of non-payment, but the general idea is to balance freedom of contract, so it also allows contractors and subcontractors to contract out of that 28-day time limit. But if they fail to do so, it establishes a basic 28-day payment period.
Okay. There are also changes proposed to the timelines for preserving and perfecting liens. Maybe explain what these changes are.
Sure. So just like under the old Act, liens need to be preserved by registering a notice of lien on title to the lands in question in the appropriate Land Registry Act. And under the old Act, there were 45 days within which to do so. Now, under the new Act, you have 60 days to preserve a lien. Much like the old Act, liens still need to be perfected, and that's done by commencing an action in the Ontario Superior Court of Justice and then registering a notice of action on title to the lands. The deadline for perfecting a lien has been extended from 45 days from the latest date upon which you could preserve the lien to now 90 days from the latest date which you could preserve the lien. And I think the idea behind this is to allow for more time to potentially resolve disputes before the timelines have to be met.
Okay. Bill 142 also proposes a new interim dispute resolution mechanism. Maybe you could talk a little bit about what that process will be.
Right, so the interim dispute resolution mechanism is an adjudication that will be available for certain types of construction disputes. Either party can refer the dispute to arbitration, and the arbitrator will have to release a decision within 30 days. And that decision will be binding unless the matter proceeds to further arbitration under the contract or to the Superior Court of Justice. And this will create a much quicker turnaround time for an early decision on construction disputes. So lawyers and their clients are going to have to work much more quickly to put forward their positions than they have in the past.
Okay. There are many other changes to the Act proposed by the bill, including changes to the holdback and substantial performance provisions. Maybe you could comment on some of those too.
So one of the other changes will be to the mandatory 10% holdback. That amount will continue to be held back, but in the new proposed version of the Construction Lien Act, there are mechanisms for there to be a holdback paid out on an interim basis or a holdback paid out on an annual basis. And part of the rationale for this is that large construction projects can go on for years. So by having these provisions in place, it will allow for an earlier flow of money down the construction pyramid. Now, having said that, there has been some indication from the government that there will be staggered enforcement of the Act. So we don't know which parts of the Act will come into force immediately and which parts might take a little while to come into effect.
Okay. Thank you, David. If you have any further questions about these changes to the Construction Lien Act, please contact one of our commercial litigation lawyers at Nelligan O'Brien Payne. Thank you.